Good afternoon, ladies and gentlemen. Welcome to the technical session of the ASEAN Seed Congress Standing Committee on Intellectual Property Rights and Biodiversity 2017. My name is Kunaporn Pantunin, Membership Programs Officer from APSA. While my full name is a bit difficult to remember, you can call me Kuna. As a Membership Programs Officer, I'll be here to support our members regarding to technical session programs and study tools. If you are interested to join our activities in this group, our chair and co-chair are here to update you in a moment about our upcoming future plan in 2018. Let me not wasting time. May I invite the chair of this session, Dr. Arvind Kapur, CEO Rasi HyVeg, and co-chair Mr. Casper Van Kampen from AIB to be on the stage, please. Thank you very much. May I also invite the chair of this session, Dr. Arvind Kapur, for the opening remarks, please.
Very good afternoon to all of you. So we are going to start this session now, and we have the program with you, and we will cover a lot of different topics. And we have all the presenters are here now, and I hope that you will all get the information. There are a few housekeeping to this committee that as you know that we, from the IP committee, we started one project about survey of IP situation in APSA region. Last year we put this in the last meeting, and we circulated to all the NSAs and members this survey. It's a very sorry state of affair that the response to this survey was poor. Though this issue of IP, we want to help our member countries after hearing that what our companies are facing issues or something which is happening positive or what kind of things are there in their countries about IP laws. Then APSA can help by putting some efforts to talk to the regulators or talk to the lawmakers that how it's important for the members. So I think I requested APSA Secretariat to in this meeting they may circulate these survey forms to you, and please try to fill it up because they are very simple questions. And whosoever is in that country, whatever you know about it, please fill those survey forms. It will help us and help you to design our future strategies papers and how we are going to help you in the IP issue in your country. So my request to all of you who are here in the room from different countries, they should fill those forms, the survey forms, so that it will help us to at least survey that where we are in Asia regarding IP. So this is what, just to inform you, with that we will start the program. I will ask Casper to now introduce and start the program.
Thank you, Arvind. Well, my task is in fact, a very honorable one. That means to introduce you. and the point is that I can be short because everyone knows you. This is Arvind Kapur, ladies and gentlemen, Managing Director of the Axon HyVeg Limited. And he's, for quite some time, our chair of the IP and Biodiversity Committee. And also, I think it's worthwhile, besides your academic background, Arvind, to note that you're a former Secretary General of the National Seed Association of India. and you are also part of many other industry organizations. And for me personally, it's also important, I think, for the public to know that you are presently engaged in awareness program for IP-related issues in Asia and globally. So, take the floor.
Thank you. Thanks, Casper. The issue which I want to discuss with you, the farm saved seed and the farm privileges which are there in the law. Most of the presentation which I concentrate that because this issue is raised in many countries about how to handle the farm saved seed and the protected varieties and what our law says in Asia and what is the background that because we are living in different backgrounds now. So to start with well, you see that this farmer saving seed was tradition because many thousands of years ago, farmers, they want to have their own seed because there's no supply chain system and they were cultivating the land at that time with their own saved seed, both for annuals and perennials. And this is what the situation was many years ago. And then you have the 20th century. So the shift is very visible now that you have the plant breeding which brings the seed every year new, and then farmer try to buy and have the profitability better. Well, if you see the farmer use seed for sowing, why farmer save the seed? That he's not sure that whether he will get the seed at the time of planting. And he also feels that there is no advantage between the saved seed and the seed which is purchased, and then the disease free and the he wants to select plants which are a little bit disease free, and that is how he created the land races of many years back. And if you see that that the risk factor if the environments are changing. And during a very high risk, if the growing is delayed, he want to use his own seed rather than the purchased seed. And maybe he can also thinking that is a cheap and easy to access seed from his neighbor, which is again a farm saved seed to cultivate. Well, the position in UPOV, both in 78 and 91, is very clear that there is a privilege provided to the farmers, but it is privately for non-commercial purposes in 91, and also safeguarding the legitimate right of the breeders. And a farmer can use farm safe seed in his own land holding, though it is defined that depending on the land holding, it's small and medium farmers. Less than 5 hectares or 2 hectares, there are different countries are using different parameters. But yes, they are using partly or fully on his own land, not for the sale. Well, the present legality of the farmer saved seed is that since it is a saving seed and exchanging seed of farmer for biodiversity purposes has been a traditional practice, as you know. These practices become illegal when you have the patented or protected material by breeders and corporations. And also you know that under Article 28 of WTO TRIPS, which says very clearly that planting, harvesting, saving, replanting, and exchanging seeds of patented plants or plants containing patented cells or genes can in some cases prohibited by IP laws as per the member who signed the WTO. The farmers of the developing countries are affected by prohibiting, and then UPOV 91, it says that farmers privilege, where farmer can or reuse harvested seed or protected varieties under conditions but not for exchange purposes. There are many cases are there in 2002 between the Pioneer and then is the Monsanto, where the patent infringements were filed against the farmers, particularly in soybean cases. And these cases also establish the fact that if the farmer used the patented material, then there is infringement. Well, if you see the farmer privilege in Asian laws, many countries have accepted 91, but many countries are still in 1978. Well, if you see the farmer's right, particularly in the Indian PVP Act, it says the farmer is entitled to save, use, sow, resow, exchange, share, or sell his farm produce. So the issue is only he can sell also, but not in the branded material packet. So that is the exception. That is why India is not yet the UPOV member. Recently, the Pakistan also passed the Plant Breeders' Right Act in December 2016. But going through that, there is no mention of farmers' right there, though they accepted UPOV 91. But in the past law, there is no reference still. But what I heard that they may in the rules, though there is one reference is there, maybe when they frame the rules in their act, maybe they mention there the UPOV 1991 privileges. We say that sometimes there is a discussion that is initial cost of buying certified seed is discouraging farmers because people talk about price. I think saving seed and buying farm-safe seed is usually a lot cheaper, as we know that, than purchasing certified or truthful label branded seed from external sources. Sometimes we ask question that whether they worried about the cost. The answer is no, because we talk to many farmers and they say they grow these seed and they put all the inputs, whether they buy seed or they put their own seed, the input costs remain the same because the reason their all cultivation practices remain the same. So I think that is how they say that this is not the cost which is important. And also the quality of the seed which they find after the certified or the truthful labeled, the quality of the seed is much higher than the seed which they use. So I think when the benefits are being discussed with the farmers, they really like that if they buy seed and they don't reuse the seed. And particularly in those crops where the final product is not the seed, particularly vegetables, farmer doesn't want to have its land busy for another 6 months to have the seed. So there's no benefit to him that to keep the land busy for another 6 months to have some seed saved for his next crop. So I think what we are seeing in vegetable crops that all open pollinated varieties, even though it is easy to produce, but farmer is still not producing the seed and still buying the seed. So I think there is a clear-cut indication that farmer in the present century is not interested. But yes, there are emotional issues and political issues that still talk about farmer-saved seed. Well, if you see the all that that how we produce seed and what is the difference between farm seed and the commercial seed, so you know that we do so many operations by the technical staff that how these seeds are being produced under isolated conditions and disease-free and all off types and other things. So I think when we see that the benefit, if it is explained and farmer knows about it who are producing our seed and farmers who are growing our commercial crops, both are very, very clearly know that the seed which is produced by the farmers who are expert in seed production and they know what kind of information they are being supplied, that what you have to do and how many operations you have to do to give a very good, truthful label, good genetic purity, good physical purity, good physiological purity, the value. I think farmers are looking into these kind of things that their fields are sown in a very good way. So I think when the differences are explained to the farmers, they really want to see that what the product they are getting or the seed they are getting is much better than if they have their own seed. Well, there are also what I said that disadvantages that people are there are crops which are self-pollinated or cross-pollinated or they are pollinated by insects or wind. The isolation distance and genetic purities are very important. And sometimes farmers in the commercial area where you want to save the seed, there are many type of varieties grown side by side. And if you save the seed, you know that what he expect in the next season. And also that we see that there is a risk also mixing of varieties and getting the produce which is mixed type, and I don't think it get a good market value because we have seen sometime the product which is coming out of the farmer saved seed, it has many types of grains or many types of things where the buyer at the market levels give very poor rating. So I think farmer, when he sees all these things, he get back to the seed which he purchased from the right source and then use for the production. Well, there are when we say certified seed under expert, and also there's a surety by law that if there is a discrepancy or there is some kind of shortage of quality, farmer can always get compensation, because the reason is if he saves his own seed, if the laws, neither the insurance company nor the other can ensure that he will get any kind of benefit. So I think these also, now there's a crop insurance schemes where these companies also look into that, what kind of inputs and what other thing he used. So I think this is also encouraging farmer to move from the farmer saved seed to the certified or the truthful labeled seed. Well, benefits are there that, as you know, that when we produce seed, I think these benefits are all our players or the members who are selling the seed, they always explain to the farmers that what kind of seed you are getting when you are following certain systems. And I think where the seed technologies which we are releasing, which is coating, pelleting, priming, and these technology also help farmers to get better stand and better crop production. So I think that in farmer saved seed, you cannot do that, because the reason is he's just maybe hearing from somebody do the dry treatments, and those treatments are not according to the dosage which we want, and he never get the benefit out of those dosage. We have seen in corn, some of the farmers, they use imidacloprid, and we find that there's no benefit he got, because the reason is neither the coating was done rightly, nor the per seed coating which is required is not proper. So he got no benefit, though he spent money on it. So I think there are many issues which were found that when we supply a real coated and treated seed to him, he get the early benefit, which is we mentioned in our promotion material, that this benefit will give to you if you use our seed and you have better stand and better protection. Well, hybrid seed is a deterrent because hybrid seed, if he save the seed, he is a loser. So I think that also make a little bit in many crops that farmer saved seed is not an issue, because the reason he buys the seed every year. So I think that is where the possibility that where we give him a better traits through the biparental or through three-parent when we use it, so we can put traits better and stack the traits better. And farmer also knows that autotic value is much higher than the open pollinated varieties. Well, there is a Canadian study in the Brassica napus because there was a controversy created that the farm saved seed, and they have a relatively very high price, and in some of the years the produced price was very low. So they conducted 8-year studies in Saskatchewan and Alberta, and they found that some farmers also saved the seed of hybrids. Though the open pollinated varieties, the differences were not so much, but the untreated seed has really affected the yield, because they found that when they sown open pollinated, untreated and treated, there was a difference. But in the hybrid, the differences were enormous. So there are farmers who thought that only a 10%, 15% reduction of yield is acceptable, though the prices are very low, but ultimately they lost. The reason is, so that is why the 8-year studies have really demonstrated that these two things, because when you have issues like that and people have to demonstrate, I think this study has really done a good job that you can distinguish between the farm-saved seed and in both open pollinated and hybrids. There is an Indian study also where they found, in wheat particularly, that where farmers saved seed because there is a 6-month gap between the harvested crop and the sowing, and they found that there is the problem with the variations, the problem with the storage past germination, and we find that even the weeds populations are higher. So I think these studies really show that for under the National Seed Project, that where the farm saved seed is really not helping farmers. So farmer, though we say by many laws that the farmer saved seed should be encouraged, but I think we're not thinking that the farmer saved seed which we are encouraging is having a negative impact. And really farmers who are good farmers, they don't do that. They always buy. And we have seen that our corporations and national seed corporations, other corporations, they are really selling large quantities. That means farmer is coming back and back to them to buy the certified seed. So I think when you see that, particularly in the rice also, we have seen the wheat population increased tremendously in the farmer-saved seed. And this has been demonstrated many times that, farmer kinoclova and those kind of weeds, which are very common in wheat and reduce the rice yield, rice, and the genetic purity really, because rice is also a traded commodity, and if your rice quality is not good, you can't get the right price, and the chalky seeds and those seeds are really increasing. So I think all these issues which we are demonstrating to the farmers, the farm-saved seed is not that helping farmers, and we are not stopping farmers to save the seed, but at least we are making him aware that what the benefit or loss you will get if you save the seed. Well, it is a challenge for breeders, right, in open pollinated, because the breeders said they will not get any royalty if the farmer can even save seed not only for his own land but also for the over the fence sales, which is very common in Asia. So what is happening is that the private breeding, particularly in open pollinated, is now at a very low level. So most of the breeders, wherever possibility, they find heterosis, so they go for hybrids, and they are not breeding in the open pollinated except the public sector, mostly engaged in this low price segment or the big volume segment. So I think that is also one of the factor that to get performing seed even in the open pollinated, if it is done in the right way, the yield differences and the performance differences are there. In the conclusion, I can say that if you see the total growing cost in a farmer's field, the seed cost is 7 to 10%. And for 7 to 10%, if you are losing your 90% efforts in growing crops, I don't think this is the right trade-off, because farmer understand that whether he sow the wrong genetics or the right genetics, what difference it will make, because the fertilizer used, the chemical sprays, the farm operations, he does the same for everything. Only seed is the difference. So what we are saying is that if you are spending only 7 to 10%, then seed cost is not the issue, because that in vegetable the seed requirement is very, very small and goes through the nurseries. So I think there are benefits if you buy the seed. And also we say that in the 21st centuries where we are living today, we have a lot of stresses. We talk about climate change, we talk about climate shifts. I think that also putting pressure on the breeders to release variety every 3 to 5 years. So the life of the crop, or we call it open pollinated or hybrids, is both reducing. So I think in that case, if saving seed will not help anyway in the farmers, and farmer is the major effort of us is to for the farmers easy of growing crops. What he wants, that my operation should be reduced to few. If you have technologies, he has to spray less, or they are efficient user of the fertilizers, so you use less fertilizers. So there are many benefits we are being accrued to the farmers through the technologies. So I think in the Asia now the demography is changing. The farmer is no more, he needs food only for family and no extra money in his pocket if he grows a very poor quality crop. So he wants that the extra money should be created in his pocket so that he can get these benefits. Well, we say the concept of farmer-saved seed in many crop is disappearing, either due to hybridization or better quality seed. We are not seeing it, though the plant breeding innovation in 21st centuries are making sure that the yields under all conditions should go up, because whether there are stresses, the plant breeders are on the job to give the better seed. So I think our job is to give farmer the best out of our seed, for which he is spending the money. Our present laws are still in 19th century, because if you pick up the laws in the Asian country, they say farmer-saved seed and farmer-saved seed, and they don't want to compromise on it. And we have no quarrel with it, but I think the issue is that we have to encourage farmers to grow better, because the reason is the land is shrinking resource and urbanization is really catching up. So what we are getting a very small area, and we have to take productivity per unit areas higher. And that is what we want, and that is how to help farmers. So I think that is the job, and the last statement I can make, that every cent farmer is spending on seed, we as a plant breeder give him multiple dividends and profits. So this is what our job is. I think this is what we are giving message to the lawmakers, that I know there is emotion and political issues are there for the farmer-saved seed, but does it help the farmers? I think that demonstration is not there. Thank you very much.
Thank you, Arvind. I think, ladies and gentlemen, that when we prepared this, I think we owe you an explanation, because we realized that what Arvind detailed out for you was, to a great extent, preaching to the converted. But we had a question, and that was also linked to the survey, which was mentioned by Arvind, which we sent out. When we are selling farm-safe seed, as Arvind pointed out, that is illegal. That is legal in many countries. That's a fact, and we cannot change that. We have to respect that. And a farmer is sovereign in his decision to use farm-safe seeds or to buy the often more expensive original seeds. But within our committee, we had a question, or we still have the question, which we like to have answered by you this afternoon. Should we prepare tools to bring out the risks of the use of farm-safe seeds, and on the other side, the advantages of the use of original seed? And tools to, then I mean simple communication tools, to be put at the disposal of the seed associations, members of the seed associations. And you could think of leaflets, short animated videos, which could be prepared in several languages. So we were thinking, is there a mission for APSA to develop a practical tool for the seed associations to be used by their members, in particular the breeding companies? Or should that be left to the individual breeding companies? That is a major question when debated in our committee, and where we decided, okay, let's consult you to answer the question, where would you like to see us make our efforts in, say, the next year? So maybe I can invite you.
Sir, I am Jayveer from Hyderabad, India.
Is it working?
Sir, irrespective of the legal position, no farmer is saving any seed, particularly in southern part of India.
You know, sorry, it's not on. That will help.
Hello. Sir, I am from Hyderabad, India. In southern India, no farmer is saving any seed, even for OP varieties, even for clistogamous types like groundnut. In groundnut, actually, farmer saving is necessary, but farmer is still dependent on government subsidized supply. So there is no need to campaign. In India, even if you campaign for saving of the farmer seed, they are not doing. For no farmer is prepared to save his own seed. Thank you.
No, it's right that the only issue which we are debating, that when we talk about the real situation and we talk about the laws, and there are two different things then we talk, because the reason is, if you see some survey reports and something, and very different information is coming, some say 50% farmer saved seed, some say 25% farmer saved seed. So there is no right information, because laws are made and then we say farmer can sell or so. But what is happening is an issue that in the name of farmers, there are many fly-by-night players come and they try to sell the seed of branded quality or maybe protected varieties. So that is where the information which Casper talked about, that if we can, we have a plant breeding innovations in ISF, we have a very good paper, and where we can demonstrate to the farmers that, what a plant breeding innovation bringing to you, and for a very small cost which you are spending on seed, you are putting the risk of getting the crop which is not, you will recover your money in multiple ways of the seed cost which you spent on your sowing. So that is what we want to show to the people who are making laws and the thinking which is going on, and that is what we want to change through this the kind of flyers which we want to give you, and with the videos or to the national seed associations, that at least they, wherever they go, they demonstrate that how the plant breeding innovations and how the new varieties bring better prosperity to the farmers. Farmer can still save the seed. We have no quarrel with it. So we are not. What we are showing him that what will benefit he will have if he get the seed which is better developed.
Yeah. Well, thank you for your comment. Is there anyone else? The next. Francois.
Yes, François Burgot from GNIS. Thanks, Arvind, for this presentation. Regarding your question, Casper, I think that it's not efficient to have some tools or some guide at the level of APSA. The situation of countries is very different, and the main question is how farmers' organization may be confident in the discourse, in the words of the breeding companies. And I think it's very necessary to have this debate at the national level, to have this debate with farmers' organizations. Secondly, regarding the tools, you have to avoid absolutely comparison to say, oh, certified seed is quite better than farm-safe seed. If you are a good farmer in self-pollinated crop, it's easy to do good farm-safe seeds. The quality, if you are a good wheat farmer, a good rice farmer, your own seeds may be at the same level of quality than the seeds which are on the market. It's not the question of the quality of seeds. It's a question of varieties. And here I would have another remark. You can say, I think, that farmers are doing farm-safe seeds for 12,000 years. What farmers did 12,000 years ago is very different. They did seeds. They made seeds, but not farm-safe seeds. Farm-safe seeds is really a copy of a new protected variety. And the debate is on that. If regulation, if law is authorizing, as in many countries in Asia, farmers to copy the protected varieties, it's finished. So the only debate is to convince farmers that at the end of the day, if they want to have new varieties, if they want to have better yield, better crops, they need to pay for innovation. And innovation, it's something you have to pay. And I think it's the only debate, and we have to avoid all the other debates around. Last remark, also you said, oh, farm-safe seed, a lot of people said it's to keep biodiversity. No. If it's farm-safe seeds of all varieties, we have no problem, but 99% of the farm-safe seeds are farm-safe seeds of new protected varieties.
No, you are right, Francois. The debate are two. One is that you want farmer to improve his cultivations. In certain areas where farmers tend to save whatever seed they have and still go for a very low productivity. We have certain areas in Asia where farmers are still, and they become like land races, because they continually selecting and saving and doing it, and they create a kind of, very low productivity. But yes, the debate is that if the protected varieties are there and farmers are saving seed, it is not encouraging the breeders to go into that area, and if they are not getting any value out of it. So that question still remains there. And where the law says that farmer can save the seed of those varieties, even protected, but he cannot sell as a brand seed of that. So that is the question which we are debating, that how it will solve the issue that, if farmers are not keeping that quality, even if he's saving the protected seed, even then it will not work, because again we find that the quality is not that good.
Yeah. Just a comment to your first point, Francois. I apologize for not having been very clear. The thinking was not to produce, say, an overall one-fit-all APSA brochure or whatever, but much more the idea of coming or working with one or two national seed associations who express interest in this, and to zoom in to that local situation. And then also the sector will have to be chosen, because field crops is different from vegetables or from rice. So, yeah, I'd like to clarify that point.
Any question more? Last?
Sorry?
Any last question?
Well,
We have to have the...
we still be good in time. Thank you. Any other comment? Or suggestion? We always welcome your advice. Yes. I cannot see who it is.
Anothai Chumsai, advisor to Department of Agriculture, Government of Thailand. We have PVP law, we have seed law. Some trouble is there when the NGO from abroad supported big fund to the NGO headquarters, Southeast Asia, placed in Bangkok. They have the movement to newspaper, television, radios, media, poster roadsides, poster in the Ministry of Agriculture, poster in farmer cooperatives. Please be the right to have our own farm safe seed as 1,000 years ago. If those people not come to interfere, we would like to be modern countries, agricultures, and the world kitchen to supply all sort, ready-made, semi-ready-made, and fresh product throughout the world. This Thailand intention. We cannot go further if our advancement in plant breeding and seed science and technology cannot cope, because these people win agitation, win disturbed, win movement, win against the government. Now we under control by the special law, since it is military government. They cannot move too much. In next 12 months, we will declare new democratic election, then they start moving. I used to be the breeder right and the seed law committee of this country. When I was young, of course, about 60, now I'm 80. Surprisingly, not modernized in agriculture as it is, as I wish. Why? The NGO supported by known and unknown fund. I don't want to say American, Europe, or Asian fund. But they have the bad people there. Sure, you go and search for me. They have the bad people there in their brain, in the way of thinking. They would like to be free, everything. Walk here, take the seed there, our seed can keep it. Now we have the case in the court. When we do contract seed production, F1 hybrid, they keep in their pocket. We used to have about 3 tons of the hybrid seeds. Next year production season, they may come to 10 tons. Why? They use the safe seed, they keep it secretly, our parentalize. That's illegal. That's why seed law and PVP law so crucial, so important for our Southeast Asia and Pacifics. Thailand, as a developing country, still have those bad people in the farm, in the roadsides, and in NGO. I explain you is the facts. We also trouble now. They don't want to, we declare and revise our PVP Act. They don't want, we would like to revise, modernize it every 5 years or 10 years in our PVP Act. Make me headache. I have to drink more tea and coffee. Thank you.
Rightly said, your comments are really valid, that really not only in the farm safe seed, the NGOs are active also in the technology introduction in the agriculture. So they are, and most of them, they are not farmers, and but they have the power to engage those people who are not knowing things, and they just are followers. So I think these issues are there in Asia, where most of the NGOs are becoming so strong that, you know, they carried away everything that they want to oppose with no rhyme or reason. If you ask them to debate and come to the debate table, they will never come. They only come in the masses because they can shout and make a rule differently. So I think these are the challenges for the industry, and we are very confident that the plant breeding innovation will dominate and will help farmers in future, and farmer will come back to us and buy the good seed.
Thank you. Before I announce the next speaker, we change. Any last comment, suggestion? Is there any one of you who knows of a existing, say, communication tool which is in use by any of the national seed associations we could learn from? Is there any program in this respect already active, where you say, well, that could definitely serve as an example for us? No. So there's a field to explore. Thank you, Arvind. My role to introduce speakers is an easy one this afternoon, because the next speaker is very much known to most of you. It's in fact only the people who are completely new to our forum who will need an introduction. Anke van der Hurk has been here quite often already, and we are very grateful that she's prepared to also be here today. Anke is Deputy Director of PLANTUM, the Netherlands Association for Breeding and Trade of Seeds. She represents the seed sector in the CBD, the Nagoya Protocol, and the ITPGRFA. And if you don't know the abbreviation, she no doubt will explain you that. And she's actively involved in the implementation of the international agreements in Europe. But I know, Anke, you're traveling around the world, and you're helping also, you're advising other countries as well. You are known to all of us in ISF, in the European Seed Association, and also in the ICC. And also, we've seen you often here because you have been serving as member of the executive committee of APSA for, say, the past 6 years. Anke, we asked Anke this afternoon to give us an update, but also with a specific orientation. And that was, okay, what are these developments, which are often still under negotiation, and here and there with some decision points reached, and what impact does the things which are having been are under decision or have been decided, what impact do they have specifically for the seed companies? Anke, can I invite you?
Thank you, Casper, for this nice introduction. Indeed, I will try to look at the consequences of international biodiversity legislation for seed companies. And indeed, many of you know that I have been trying to do this already a couple of years, and I know it's a very difficult topic that for a lot of seed companies is still very far from their daily business. But as I probably indicate every year, it's getting closer and closer to you. So we all face challenges, and we dealt with challenges, we deal and want to continue to deal with finding solutions for all the different challenges we face. So we develop, and will continue to develop varieties that are better in yield and or quality. And to do so, we use and may continue to use any genetic resources from the gene pool of the crops we are working in. And you heard me indeed say, may continue. We would love to continue using any genetic resources to develop the best varieties for growers, farmers, and consumers. But we are not sure if we can still continue to use all genetic resources, and if they remain available, and if so, under which conditions. And that is due to this biodiversity legislation that is there in the world. So, biodiversity legislation, we have two streams. We have, on the one hand, through the Convention on Biological Diversity, the Nagoya Protocol, dealing with access and benefit sharing for all genetic resources. And on the other hand, we have the ITPGRFA, or the International Treaty on Plant Genetic Resources for Food and Agriculture under the World Food Organization. I put in the slide here the region we are focusing in, and you can see under the different pictures who of the region are a party to either of the treaties. The Nagoya Protocol, we have in the region, if you include the Middle East, 38 countries that are a member. In total, there are now 100 members to the Nagoya Protocol. And in the international treaty, there are 26 members from the region, and there are 144 members in total. So there are in the region a lot of countries, at least from one or the other convention, they are a party. So we all know, and I think we all know here in the room, that conservation will cost money. Just conserving those important genetic resources, you can't do it for free. And we also know that at a certain stage, if you want to access genetic resources, it will not always be for free anymore. You are either caught by one of the system or by the other form of the system, or all the administrative matters that may be related to it. So, okay, this biodiversity legislation, where is it going to impact on your work? And I would like to discuss 4 items this afternoon. I want to look at the scope of natural resources, because if you look at the Convention on Biological Diversity, it is on natural resources. So what is in, what is out, and how should we, when we discuss with our policymakers, deal with this scope? And a very particular element that came up very lately now also in the biodiversity debate is digital sequence information. Is just reading a DNA structure, is that in or out of the scope of the different conventions? And then I want to look to access and benefit sharing. Where are we? What are your obligations? And then another topic that links to the topic of Arvind, farmers' rights, because the International Treaty on Plant Genetic Resources for Food and Agriculture deals with farmers' rights, where UPOV is dealing with the farmer's privilege, and those things are very often confused. So if we look to the scope of the conventions, we are convinced with the people that have been discussing this more and more that it is about natural resources. Those conventions were developed to protect natural genetic resources that were threatened by extinction. Those conventions were not developed to conserve commercial varieties. That was not the intention and has never been the intention, but we now see sometimes that people also include commercial varieties in the scope. So we think that it is good in all the discussions you have with your authorities, get the scope clear, but also get clear that it is about those genetic resources that were natural and are at risk of extinction. So I hope everybody will take that at heart. Then, indeed, if you read the definitions of the Convention on Biological Diversity, the basis of all this legislation, then you can see that it is really about plants, organisms, or maybe even genes, but it's not about information. And as people have the idea that there are loopholes in the system with just plants, organisms, and/or genes, they now also want to include digital sequence information. But let's face, what is that going to do with us? If you cannot even read a DNA sequence anymore in a book or on a database or wherever you like to find it, and you immediately have to tick off and start to negotiate an access and benefit sharing agreement, that would be very tough. And so it's going to affect a lot the innovation that is going to occur, and especially public innovation, and smaller and medium-sized enterprises will be affected most because they have no lawyers to deal with all this stuff. So it is something that is really in an early stage of discussion, but I think it's good to take part in this discussion and see what are the needs. So we think, okay, natural resources, plants, organisms, or genes, fine, but don't go into this digital sequence information direction. So if we look to access and benefit sharing in the context of plant breeding, we have a lot of specificities in plant breeding that make this context of ABS quite complicated. First of all, we go from a genetic resource to a genetic resource. And it might be a genetic resource that is a natural resource, or it might be even commercial varieties that you use in your breeding, and you should be maybe already out of scope. But in principle, you are always dealing with plants, with genes, and so in principle, it is a genetic resource. What is more complicated, we know that when we develop varieties, it has parents, grandparents, and a whole pedigree. And those materials from that pedigree may come from different places, may have impact on the final variety in different ways, a little bit, a lot. So it's very difficult to say, oh, this was the contribution of this material from country X, and this was the contribution from this material from country Y. So if you have to pay to everybody, it would be a mess, and if we are not careful, you may end up paying more than 100% royalties. What is also very important to realize is that we are all dependent to each other, and we all benefit from each other. And this is a nice picture of tomato genetic resources that in the 50s were collected in Peru. They were moved to the US, then moved to South Africa, then moved back to the US, to Europe, and then moved to India and other places to still continue making better commercial tomato varieties in this sense. So we are all depending from each other, and if you are going to put borders in the exchange, we can't benefit from each other anymore, and that is really not a nice approach. So here you can see pictures of research that has been done by independent researchers on the interdependence, and the interdependence on food crops for all countries is very high. So you may say, I am the original country for this crop, but then you are depending for another crop from another country. So why not to share? So if we then look to access and benefit sharing and what it means for the different regimes, in the one, the Nagoya Protocol, in principle, you make bilateral agreements. So if you want to access any genetic resource in a country, you have to get prior informed consent. So you have to get the permission that you may collect materials in that country to do some further breeding or other use, unless the country indicates that you don't need that. And if you have the prior informed consent, then you have to make an agreement. Okay, if I use this material, I pay you this, this, and this. That can be upfront, it can be in kind, it can be a royalty at the end. If you do that under the conditions of the treaty, and the treaty is now only effective for 64 crops, then you get a standard contract. So the prior informed consent and mutually agreed term, you don't need to negotiate yourself. There is one standard approach, and you use that. So as indicated, Nagoya bilateral, so for everything of your pedigree, you have to negotiate with the country on the conditions that you may use it, while in the SMTA, you have a fixed contract. The benefit sharing obligations in the Nagoya Protocol, you negotiate, so one may be a better negotiator and get a better condition than the other. But in the treaty, everybody is the same. The conditions are fixed in the standard material transfer agreement. Then what is very important for the breeding sector is that at a certain stage that you don't need to have to pay in perpetuity, that you don't have conditions to pay until you die. And in the treaty, once a product is commercial, the one who makes the product commercial has to do the benefit sharing conditions, but the product itself is in principle out of the system and can be used without any additional conditions with regard to biodiversity legislation. Then in the Nagoya Protocol, they have invented a new system, a kind of a checkpoint system or a due diligence system. So the country of the user has also to check the user. It's not only the provider country that makes the agreement and has to oversee that the agreement is fulfilled. No, in this case, also the user country has to check the user if they do right. This we don't have in the treaty. And that is the same with the compliance checks. Yes, in the Nagoya Protocol, not necessarily in the treaty. Even though, of course, companies, when they sign a contract, they should fulfill and want to fulfill those. Track and trace, it is in both systems, you have to do that. I don't know if that is always a big problem, because a lot of track and tracing we do anyway, but of course, if you have to do it with a special purpose, it might be more complex. So, if we compare both of those systems, we have said in the industry, in the International Seed Federation and other groups that the international treaty is the preferred system for us. It understands our sector. What is good, that it is, the ministries of agriculture are negotiating the processes, while in the Nagoya Protocol, it's ministries of environment. They have less understanding of the plant breeding sector. We think that this standard contract, which is under the multilateral system, as they call it, it's nice, it's one standard contract, you don't need to renegotiate, everybody is equal. For now, as the contract is now, you have either an obligatory or a voluntary contribution to pay. Obligatory, when your final product that you have developed is not free for research and breeding, and voluntary if it's free for research and breeding, because they recognize the value of the breeder's exemption, that material can be used in this innovative process. What is also nice in the treaty is that the pedigree doesn't matter if you use 10 materials out of the multilateral system, 100 or only one, you pay only once. So you don't get an accumulation. And as I say, there is this end of ABS obligations. Once your variety is out and the variety is going to be used, you don't need to continue to pay. So now this system is only available for 64 crops. It's the wish of the seed sector to have all plant breeding activities under this system, because that would continue the flow again. So if we then look to the international treaty, they have this multilateral system, as I was indicating and explaining. But people who are governing this multilateral system, they were not very pleased that they did not see any money coming in. They said, now we are giving access, but where is the money? And of course, they started this discussion 6 years after the implementation of the multilateral system. There was no breeding finished with this material, because breeding takes a long time. So they didn't consider that. But okay, they said, we want more money in the system, and we don't want to wait too long. And then some other people, including us, said, we want more crops in the system to make it work for everything. So we negotiated 4 years to get this win-win. More money in the benefit sharing fund and more crops into the multilateral system. And 2 weeks ago, we were in Rwanda, in Kigali, where we had a week of negotiation to hopefully finalize a new standard material transfer agreement, and to have an approach to extend the list of crops. And really, unfortunately, nothing happened. There was absolutely no breakthrough. It was a fight between the demandeurs and the ones asking, and yeah, it was impossible. So the only thing they kind of preliminary agreed is, okay, we cannot live with one benefit sharing mechanism, we need more options. However, those more options should always result in money. So there should not be any voluntary contributions anymore. And everybody agreed that that is probably necessary to deal with it. People also agreed that the obligations should be different between products that are free for research and breeding and products that in the end are not free for research and breeding. But what they also said in these negotiations, because it's getting very harsh, nothing is agreed until everything is agreed. So we might continue for a long time. They now want 2 more years of negotiations till the next governing body. But to be honest, I'm not sure if we are going to make it with 2 years. And especially I'm not sure because they now also want to include this digital sequence information. And if they want to include that in this process, we need much more time because this is really at the starting part, and everybody has a different thought on digital sequence information and how to deal with it. So that with regard to access and benefit sharing, but again, realize if you are going to access genetic resources, especially from gene banks, from official places, that they come with a contract or say we have to negotiate a contract. And it's all going to hit you somewhere. Then, the last topic, farmers' rights. Article 9 of the International Treaty is on farmers' rights. And it indicates very clearly in that article that you should implement farmers' rights at a national level, because every country has its own system in dealing with farmers. And I think that was very clear from the presentation from Arvind and the discussion afterwards. Every country has its own ideas in that. They give some hints in Article 9 what should be done to implement farmers' rights. And they say you should recognize all the role that farmers have played in the evolution of land races and so on. You should involve farmers in benefit sharing. So if there is some benefit sharing coming into the country, then it should be also partly shared with farmers. And farmers should have the right to participate in policy processes, in implementation processes. They should have a role. And then there is this one Article 9.3, and that is always the challenge, and that links very much to the topic of Arvind. Article 9.3 reads, "Nothing in Article 9 shall be interpreted to limit any rights that farmers have to save, use, exchange, and sell farm-saved seed or propagating material, subject to national law and as appropriate." A lot of people read this, and especially the NGOs, they read only farmers have the right to save, use, exchange, and sell farm-saved seed and propagation material. They forget the start and the ending of the sentence. And this is causing really a lot of discussion. The NGOs and also the farmers' groups were feeling that farmers' rights implementation at a national level is maybe good, but they wanted to have something at a higher level. They want at international level support. And so they have been asking already many, many years to have a working group dealing with farmers' rights. And this year they have succeeded in getting a working group on farmers' rights, as long as there is money to run those working groups, but probably there is going to be. And I think as seed industry, and I think Arvind was making also some thoughts on it, we need to go for a balanced approach. And I found it already very interesting listening the discussion on the former speech, that farm-saved seed is for everybody something different. And I mean, whoever is right or wrong, I think it doesn't matter, but we have to see how to deal with it. And we need a balanced approach for all type of farmers. So farmers that are really smallholder farmers just over the fence dealing, maybe we should not make a big fuss on the duplication. But if a farmer really wants to be a commercial farmer, then indeed he needs to pay, I think, for innovation, to keep innovation going. I think nobody has problems to see farmers participate in these discussions and being recognized. And I think what we have to promote, and I think that comes also out of the presentation of Arvind, is farmers should have the right to choose any varieties. And I can tell you, a colleague of mine was in a meeting in Kigali, and there were some farmers, in this case from Africa, and they were saying commercial varieties are poisonous. And I mean, if this is the thought that is going to be picked up by the policymakers, I think we are not going into the right direction, and we don't help the farmers to improve. And I think when we talk on farmers' rights, we also should have the recognition of UPOV. The one should not protect the other one to exist. So it's a lot of challenges ahead, and I think we have to deal with expectation management. We see now that people have different expectations. And we have to work towards a realistic implementation. So a workable scope in all this legislation, so focus on the natural resources, no inclusion of digital sequence information. This in the end will hamper innovation on all levels, and I think nobody is getting a benefit from that if you would include it. There should be a balanced access and benefit sharing and arrangements, and farmers' rights for farmers should be in sync with UPOV. With that, I would like to thank you for your attention.
You have listened about these ITP, GRFA, and Goa protocol. I know that in Asia, still many of our members are not aware of what is going to impact their businesses in future. So if you have any question or query from Anke, please ask.
I think it's all very clear.
Oh. Or just going over the head?
You have one there in the back.
Oh, there is a question.
Oh, not. Yeah, help.
Oh, there.
My name is Paul. I have one question I need to ask about the clarification on the farmer's role. You say the farmer, they have the right to choose the cultivar they need to grow. Mostly in the politics, the government, they have the extension officer. Sometimes you see they look like they are in charge to choose some cultivar or which crop the farmer they must grow. Mostly in some country where they need to make the extension agriculture, you see the government, they need to choose the cultivar for which the farmer can grow. So I need to ask the clarification. In that time, the government, they didn't respect the role of the government, or it is in the right way?
I'm not completely sure if I understand your question, but if I understand that the governments do some extension work and give advice on the use of some varieties, I hope and I think that at least the government should follow the rules of those varieties. So if they are protected by variety rights, that they are getting the seeds legally and so on. But in principle, I hope also that if there is extension done and farmers have other IDs, that they have the right to choose their own varieties. Because I think it is important that everybody can choose what is best for him or her.
Oh, yes. François will ask, sure.
Yes, possible again. Because we talked about these treaties for a long time in APSA, I would like to stress what was shown by Hurk regarding the small agreement obtained at the last governing body about the fact that you will have, we don't know when, but you will have some compulsory remuneration as soon as you use some material from genetic research centers in your breeding activities. To be clear, many companies regarding hybrid rice are using some inbred line or some material from ERI. And in the future, every time you use material from ERI, you will have to pay on your varieties when you put your varieties on the market. So I would like really to stress that change because many companies in
No, in case of IRI, where people are using material from IRI, there's a consortium and they pay money for that. And I think there are agreements with IRI that if you're a member of consortium, you can use that material in your breeding program.
But indeed, I think there are two different systems here.
Yeah.
There is a consortium on bred materials from IRI,
Yeah.
but if you go to the gene bank of IRI, now you get the material from the gene bank with a standard material transfer agreement, and I think, as Francois rightfully indicates, now if you make varieties that are free for research and breeding afterwards, so you either not protect them or you do a PVP, then you don't need to pay. But in the future, and if that is in 2 years, in 6 years, in 10 years, I don't know, but in the near future, you are always going to pay. So there is always, if you develop a variety out of it, you will have to pay a percentage to the treaty. Or if you don't want to pay a percentage at the end, you have to pay a membership fee. But that is a different thing than this consortium, because that is on advanced material. So that needs to be made very clear, I think.
Please, I have to add, you need to know that the consortium ERI policy was a lot challenged during this governing body. And the majority of parties of the treaty would like to ask to ERI to change its policy. Even in consortium, there would be SLT, and there would be compulsory remuneration for the beneficiary fund. And and Biodiversity was clear about the fact that they will do that, and they will no longer have some agreement apart of the policy of international treaty.
Because we have in India the National Biodiversity Act, and also we have signed the ITPGRFA, and we also party to the Nagoya Protocol. But at presently, we have a difference between the Plant Variety Protection Act definitions and the definition under National Biodiversity Act. So both acts are actually loggerhead with each other. So now there are efforts are being going on to make it a harmony between, because it is not the NBA which is asking all the companies who are operating in India of foreign origin, or they have any shareholding of foreign companies, they have to take permission of NBA for all material which is going out of India or being used in India for collection purposes. So there is a difference, because that is what the efforts are, that all the agriculture biodiversity should be handled through the ITPGRFA and through the protected varieties. But there is another issue which is coming here, in that our Plant Variety Protection Act, if we protect a variety, you have to pay the royalty of 0.02% on the sale of that variety, only protected varieties. Not if you don't protect varieties, you need not to pay anything. So there is also a very, very kind of strange access and benefit sharing, which is being created there in different laws.
Yeah, indeed. If we look at India, it's very challenging to understand. I mean, I understand for you it's already challenging. So for us in other languages, it's even sometimes more challenging. But what we feel that indeed India ratified the international treaty. They have collections in their public domain that would fall under the list of 64 crops. But unfortunately, until now, the private sector cannot get materials out of that multilateral system out of India under the SMTA. They have not implemented that part yet in practice. So I know they are working on it, but indeed different ministries, so very complicated. And indeed then there are their own national laws that are on top of the international obligations.
question. I know you were talking about the results of the outcomes of the governing body meeting, and that's nothing really to agree to. But what was the vibe or the discussion on extending it from the 64 crops to cover everything? I don't think you had that in the sort of answer.
No, it's a very good question, Michael. And here there was a big disagreement between countries. In particular, the developed countries want to extend the list to all plant genetic resources for food and agriculture, while most of the developing countries are against at all or against for now. They first want to see money coming in, and then they want to maybe move on. But yeah, some countries feel that giving the material in the multilateral system takes away a little bit of their control. I think very understandable. But indeed, absolutely no agreement on this part.
Any other question to Anke? Thank you, Anke. Thanks for your presentation. Over to...
The next speaker needs an introduction because I think he is new on this platform. I'm happy to introduce you Mr. Tomochika Motomura. He is from UPOV, and he is here in his capacity as technical officer for the Asian region. Mr. Motomura has a long career in agriculture, in the Japanese government, in various roles. He was working for the ministry, and he also worked with the Japan International Cooperation Agency as senior advisor in rural development, and also there focused on agriculture. Mr. Motomura will update us on the latest developments within UPOV. Can I introduce you? Can I invite you here, Mr. Motomura? Thank you.
Thank you very much. So, nice to meet you. As I introduced, my name is Motomura, but my name is quite long, so please call me Tom. So it's easy to call that. So I'm going to report on that new development in UPOV. Firstly, we got a new member of UPOV. So it's 75th members. It's Bosnia-Herzegovina became the UPOV member very recently. Secondly, last UPOV Council session, which we held last month, October. So we got three countries which got positive advice. So it's the Brunei, Dar es Salaam, and Guatemala, and Myanmar. So if we see this Asian region, we got Brunei, Dar es Salaam, and Myanmar. And regarding the Brunei, so they submit us their PVP law. And regarding Myanmar, they submit us a draft PVP law. This is good news. So we are waiting for them to become a UPOV member. I'm very happy because I'm taking care of the Asian region. Yeah. So after 2006, we got Vietnam as a new UPOV member. So after that, so we have no movement in this region, but we have now seen that new movement in this region. Then, so this is a UPOV map. So green colored country is a UPOV member. So which covering 75 members. It means that it's covering the 94 states in the world, and that the other colored countries that initiating states or states in contact with the UPOV office. Then I'm going to explain about the statistics. So when we see that the trend of that application of the plant breeders' rights, it's increasing, very increasing. Especially, so we color that region, and we see that the blue colored part is that from the Asian Pacific region. So you see that the Asian Pacific region is that growing as the engine of the growth of that increase of that application of the PBR. It's very interesting figure, I think. Then I'm going to talk about the PBR application tool. It is called as the EAF, electronic application form. So we got a new name for that. It is, so new name is the Prisma, and this is a new logo for that EAF project. Then I'm going to explain about the key benefit of that Prisma. Firstly, it's online PBR application tool, one thing. Then, so that's Prisma has the range of the languages. It means that if you answer the question on the that site, it will create the a lot of language, and in that form, it's which the PVP office is requiring. Also, you can reuse that data you input it in that form. It means that, for example, if you input data for that to apply, for example, USA PBR, then you can reuse that data, for example, to application to Argentina. And part of that, what you inputted is that automatically translated in that, from English to Spanish, like this. And also that you can allocate user roles, and that it will be you can control access and secure, and then it's easy access, and also you can track your application. So there's a lot of benefit to use that Prisma. Then, if you visit the UPOV website, so if you want this Prisma tool, you can visit this blue color part. And if you want to get the information about the Prisma, you can visit there. Then, nextly, I'm going to talk about that the covering of that this Prisma tool. And now, 16 UPOV member is participating in this project, and this project also covering just 5 crops, and you see that this table. But so we are going to expand that covering of that this tool. Firstly, so from the next January, Bolivia, Canada, EU, Georgia, Mexico, and Paraguay will going to participate in this tool. So you can apply to these countries by using this tool. Then you see that the new covering, new expected coverage of that EF of this tool. Also, in terms of the crops, so a lot of countries going to cover all crops by this tool, and other countries also going to expand that covering by this tool. Then also, now this tool can have the navigation language as English and French and Germany and Spanish and Chinese. Then we are going to add the Japanese as a navigation language. So I'm from Japan, so I'm very happy about it. So we are going to have the Japanese as a navigation language. And if you have, if you want to know more information, please ask by, please contact us by this email. So nextly, I'm going to talk about the benefit of the UPOV system. So we now have a lot of video clips, and we got publications. So then I'd like to focus on that new publication on that Vietnam study. So it's independent economic study. What happened to Vietnam after joining UPOV? So this study compares that 10 years before and 10 years after Vietnam became UPOV membership. Then, so I'm going to explain a little bit briefly about this study. Firstly, this Vietnam study looked at the land productivity on rice, corn, and sweet potatoes. Before, so as you know, that Vietnam became a UPOV member 2006, and 10 years before, they see in Vietnam they see the increase in yield, but it's mainly through that increased level of input, such as the pesticide and fertilizer. So we do not see no increase due to the plant breeding. But after they join in UPOV, they see the land productivity increase due to the plant breeding. For example, rice for 1.7% like this. And it means that in 10 years, so regarding rice, it's a 16% increase, and the corn almost 19%, and regarding the sweet potato, 27% increase due to the plant breeding. Then we see that this studies also that see that investigate in that income increase of the Vietnamese farmers. It means that we see that the 24% increase of the Vietnamese farmers of income due to the plant breeding. It's due to that UPOV membership. I think it's quite a good number. And this is the end of my presentation. Thank you very much.
Thank you. Thank you. And you have any questions? Okay. Yeah. Any experience to be shared with the Prisma, which we talk about electronic application system? In Asia? Or?
Okay, may I add
Yes.
something? So that I think that for the time being, there's a very little number is used, but if you visit the UPOV website, you see that the breeder's testimony. For example, it's from the Netherlands. Yeah.
Okay. Okay, thank you very much.
Thank you very much.
And yeah.
Is Michel here?
I think so.
Before introducing the next speaker, a basic question. Michel, are you here? Ah, thank you. Yes, I hadn't seen you because you're not in my view. All right. Well, Michel, I think you hardly need an introduction because you were sitting here yesterday at the same time of the day as chair of the special interest group Vegetables and Ornamentals. Michel, you are, beside that function, you are engaged in APSA. You are also Vice President of the East-West Seed Group, here based in Bangkok, Thailand. And before we share that we were both in FAO, where you started our career, in Mali and Bangladesh. And I think that is about it, Michel. And what we asked Michel to talk about was about, I think, a very practical tool for you as companies, given a problem which is, I regard as, in my function as director of the Anti-Infringement Bureau, the theft of parental lines. And that is a problem which is, from my own experience, the biggest in this region. And not surprisingly, because in this region there is a lot of seed production going on. And because of that, discussing that being a major issue from the perspective of intellectual property, because you lose your intellectual property in an unauthorized way. People walk away with your parental lines. A project was set up, a group was set up, and worked on defining a best practices code. So how can seed companies do better in, well, what I would say, putting extra locks on the door? And that study, that is the principle which was published last January, and Michel is going to introduce that and present the highlights. Thank you, Michel.
Thank you, Mr. Chairman. And, or Deputy, or Mr. I think you've covered already half of my presentation, which is good. It's going to make it. I don't have many slides for you about this, because as was said, basically, this document was published, widely published, in both biggest organizations, seed organizations in the world. This is a document that we worked jointly on. So here is a smart QR code. I was hoping that some of you could actually QR code it and access directly the document online, but it's maybe a little bit far away. Otherwise, the full link is there if you get to the document. So it's on both websites, exactly the same document. As Casper said, the background of this document was actually coming from, indeed, an IP perspective, and I think that's the reason why I'm presenting this in this group. It's about, well, where is IP usually stolen? It's in the seed production fields. And, well, what can we also bring as added value to the members? And that's sometimes missing. It's some very practical guideline. So it came about that we started working on this and creating a practical guideline on how to do seed production. And as I said, both companies, it started at APSA, and then the document was passed on to the vegetable seed production group of ISF. It was reworked. We had a lot of very good inputs, and it became a quite good document, I must say. So, as you all know, seed production is, of course, a global enterprise. You cannot produce seed everywhere. I mean, not every place is suitable for seed production. Most of seed companies do outsource, but some do seed production in their own facility. Well, in any case, the commercial seed and the stock seed has to cross borders, and because of that, it touches many hands, and sometimes many sticky hands. And we don't want that, and so we are going to try to provide some hints and some guidance as to how to prevent this from happening. And this guideline was basically highlighting what is important to consider between the relationship between the seed producer, the order giver, and the order taker. There are many things that each of these groups can do to mitigate the IP theft risk. So it covers mostly very practical aspect, down to earth, and is not going in the detail of the quality management system, which is a whole field, whole separate field altogether. So as I said, this document of about 15 pages is covering the two perspectives. The perspective of the seed production order giver, that's usually the seed company wanting another company to produce seed for them, and the perspective from the seed production order taker, that means the seed production company. And as you can see on the screen, from both perspectives, we were covering different aspects. So first of all is the selection of a reliable producer. That sometimes is a trick in itself, that who do you entrust your valuable material to? Then comes, of course, the parts of negotiating the seed production contract. You might want to emphasize and highlight some aspect of, well, what to do with the IP that you are entrusting with them. Sending shipment of the stock seed, that is one of the most critical part, and I will give you some very practical examples and some things that happened to us as a company also. And then, of course, the follow-up of the production from the seed order giver. I mean, it's always good to follow up what is going on there with the precious material that you're giving them. And, well, the last part, of course, is when the job is done, how to receive the seed and what's happening with that. Not surprisingly, the same points were addressed from the order taker part, and of course it is a slightly different perspective. Added to that, however, that the order taker, who is a professional seed company, usually entrusts further the material in the hands of hundreds of smaller farmers. And that also requires some tips and tricks on how to protect the identity of the order giver, right? And that is also important to consider. So that's why on point number 3, you see that this point was added there for discussion. All the other points are the same, and I will not elaborate in detail because, of course, the document is there as a good source. But I will also highlight, and the last portion is that there was a special emphasis on the document on alternate measures for IP protection. So beside all those general things that are set in how to address the relationship between the order giver and the order taker, there is some of these extra steps that can be taken for IP protection. So let me just highlight a few of these points. Again, I'm not going to go into much detail here, but the first and most important thing, the relationship between the order giver and the order taker. After all, it's a matter of trust. Who do you entrust your material with? You have to make sure that the company with whom you are going to give your business has a good reputation, that it's not going to use your stock seed to produce his own material, that it's not going to sell your remnant leftover seed onto the market without you knowing this. This is something that you as a company, you should be very much aware of. Who are you dealing with as a seed producer? As a seed order taker, I mean, you might think, well, I mean, every good order is good to take, but I think it's also important that as a seed producer, you might want to assess the reputation of a company, not just receiving a brown bag of seed of an open pollinated variety, which might have just been cans opened by a competitor, and given to you for multiplication, especially for OP varieties, of course. So I think it's also a matter of reputation. So trust and reputation, that's the key of this starting relationship. Now, the second very critical part, and I said I would discuss about this, is how to send stock seed across borders. So a coding of the varieties is essential, and I'm going to give you some example. Very often you see bags shipped or received bearing dimension, a code something, and it says very clearly female and male, right? So when these sheep, the seed goes across borders, it's fairly easy to identify. Well, I have here the perfect combination. I have the female and the male of this variety. Let me take a few seed of each, and I'm going with it, right? So usually a conspicuous coding system, it's important. Sometimes color coding helps, but what is important is when you send large shipment of stock seed across borders, usually don't send one parent, one pair of parents, because then of course the female would be almost 3 or 4 times bigger than the female, than the male, and then it's also easy to find out which one is which, right? So try to put all these things under the radar, try to deceive people who might get their hands on your seed. Coding and recoding, but of course, if you do the recoding, there is a risk that a wrong recoding will end up into a problem of, well, mixing up parents when you receive them. So that has to be done very carefully. Now, another thing, of course, that is important is that when the company receives the seed and is going to further distribute that to their growers, there is a need to, of course, don't mention that the company was East-West Seed on the packet to give to the farmers who are going to produce that, but repack it, recode it into anonymous codes. Sometimes companies even go to the extent of distributing seedlings, so growing seedlings and distributing seedlings to the farmers so that the farmers don't have seed in their hands. And that's one good way, because then you can count every seedling that you give and you can keep on counting them in the field, and that would guarantee that there is no theft. So this is, well, our company does that in most of our production sites. We produce seedlings and we distribute seedlings, sometimes as far as 500 kilometers from the seedling production area. This is as much trouble you have to take to protect your germplasm. Of course, another very important thing, and this is not so much IP related, it is, well, seed-borne, send stock seed free from seed-borne diseases. We thought it's also good to send, to give some information about, well, general practices other than for IP protection. But often it says, well, you know, we expect you to produce disease-free seed. But sometimes we forget to highlight that the stock seed material should also be free from the disease. And that's sometimes omitted or not clearly mentioned, or there is no clear testing of who has to do the testing of disease on that stock seed. Right, so now the other important thing is, of course, the follow-up of the seed production. I always say, if you have the chance to go and visit your seed production field, go and do that, at least once a year. I know it's not always the best season to go and visit your seed production field because, well, the crop duration is about 3 to 4 months, but you have to go there at least once. I was surprised going in seed production field with the seed producer, and the guy couldn't show me his fields. He did not know where they were. It happens, these kind of things. Right, so, and these visits tell you a lot about how your producer is organizing itself. Do you see any codes? Does he respect isolation distances? Do you see, for example, your company name in the field in which he is producing seeds? These things are never shown in reports, but you can only see that if you go and visit. So, at least once a time, and of course they might prepare the visit, but it's always, these visits are very, very enlightening. Receive regular reports, send and receive the reports. They also tell you something about acreage being planted, about number of plants in the field that you might eventually corroborate later on. Well, field inspection, that's for phyto requirement, field inspection on diseases, that's also important, either to have made by local authorities or do it yourself. Then finally, sending and receiving produced seed. It's always important to send representative samples of seeds that are produced. So often, when you're talking about vegetable seed production in Asia, a company would entrust a producing company. They would have hundreds of farmers producing, for example, tomato, 5 kilo each. Now, usually the ordering company does not want to test the hybridity of every of these single lots. So there is usually a request to aggregate this. Now, it's very important then that very good representative samples are taken. We were caught sometimes by receiving samples prior shipment of receiving, let's say, maybe the best lots that that producer had. He sent that as a sample to me, we tested it, we cleared it, we shipped the seed. Finally, we received the final produce in our hands, only to find out that 3/4 of the fields had bad hybridity. And so the investigation later on, we made us realize that they handpicked the few very good farmers they had to give us the results. So eventually, I mean, you never get away with these kind of things, but these things are happening, so you have to be aware and maybe make advance notice to the producing company that this is not acceptable. Right, and as I said here, I mean, usually the germination is done by both by the producing company, because that's anyone can do, any company can do, but usually the genetic purity, that is usually a test that is done by the order giver. And that's why there are these aggregates of seed required that say, show us seed loss of at least 150 kilo, because it makes sense to do the genetic purity using DNA technology, because it is quite costly. If you have to do that for every 5 kilo lot of seed, the cost of the test is higher than the value of the seed produced, right? So then, but all that has to be taken into consideration. The same goes for seed health, which is, the test of that is usually entrusted in the hands of either the regulatory authority or by the receiving company. Some other considerations, and maybe a little bit away from IP. Well, I mean, child labor, it's something that is being discussed, is that are you producing seed using child labor? In some countries, this is an issue, but it's good to maybe mention that in contracts also, that you don't want child labor to be used in vegetable seed production fields. And well, actually, APSA published a child labor policy, and ISF is currently working on their own version of a child labor policy, which is going to be very close to APSA's position. There are also, as you know, a very, well, quite restrictive and protectionist phytosanitary measures. Well, I mean, you know, I mean, we always talk about this, the complexity of these requirements. And the complexity is often because of re-exporting. Believe it or not, that some companies producing seed with some producing companies need to have up to 64 different additional declarations, because the seed produced in a country is imported in the Netherlands or in Thailand somewhere, and then re-exported in all parts of the world. And because of these bilateral requirements, you must be able to satisfy every of these phyto requirements. So that makes life quite complicated for seed production companies having to arrange this. Right, and well, there are also some regulatory issues, PVP and registration of parental lines. I'll just give you an example of Myanmar, where, I mean, Myanmar is projecting itself as a, let's say, new frontier for seed production, a very promising country, except that the country is very new into all these laws. And, I'm sorry, oops. And basically, yeah, new laws are being drafted for registration of varieties. So basically, Myanmar is requesting that a variety that is just entering the country, so parentals are entering the country to be produced, just to be re-exported, the Myanmar government requires the registration of both parental lines. Now, very often, the company has never seen these parental lines. Very often, it's a one-time production, right? You receive the material, you produce the seed, and you re-export it. So there is really a need for some of these countries to understand what is going on. I mean, this kind of activity for a country like Myanmar is generating foreign currency revenue, so it is a good activity to do, but by the restrictive laws that they put in place, it is difficult to do. Registration is one aspect. The other aspect is the very high cost that the registration entails. So, I mean, to register this in Myanmar, you have to pay almost $1,000. So sometimes imagine you're a seed production company and you need to produce those first 10 kilos of seed. It is almost not worth doing it, right? So I'm really pressing on doing something, and actually the Seed Association in Myanmar is actually actively involved in trying to change those laws for seed production in those countries. Now, few emphasis on alternate measures for IP protection in the seed production field. The first one is the pollen technology. Now, this is a very promising technology that is already quite widely used, but unfortunately quite expensive and quite difficult to do. What this allows you to do, of course, is that it allows you to produce the male and the female at different times and in different locations. Usually, pollen is very short-lived, but if you apply the right measure, you could store pollen up to 2 years. That is the case for solanaceous crops. Unfortunately, as I said, this technology is very widely used for solanaceous, but we haven't made any breakthrough yet with cucurbit pollen harvest, collection, preservation. Because usually the pollen of cucurbits is thicker, is bigger, more sticky, and it makes it just more difficult to do that. Other crops are in a testing phase, like papaya and marigold. It's possible to collect, dry, preserve, and use the pollen. What we also realized, because we have made some trials in producing pollen in some country and sending it on the other side of the world, regulators do not know how to deal with pollen grains. Is this a plant? Does phyto apply to pollen grains like they do to normal plants? Is there any phyto requirement for pollen grains? This is still, I think, an area where, I mean, it's not very clear. And believe me, when you are carrying a little briefcase full of pollen tubes that look like cocaine, you can end up in trouble, right? So you could avert in all these border checkups, but it could be risky for you. So another way of mitigating the, let's say, the exposure is what we call central male production. So either we do the flower distribution, we do that in some production area. So this means that you are producing the females and the male at the same time, but in a different location, but not too far away, because what you have to do then is to harvest everyday flowers from the male, put them in bags, give them to motorcycle drivers, and these motorcycle drivers would carry them to the individual farmer. It is very important to create a disconnect between the male plot and the female plot. And, but I've seen cases a little bit, in the beginning we said, yeah, you have to do central male. So some of our people understood that you have a central male plot, and all the farmers, all the female farmers, were coming and collecting the flowers in that central male plot. This is, of course, killing the purpose, and it is not useful. But this is also quite costly. You can imagine all these logistic persons driving with motorcycles every day, sometimes spanning circles of 30 to 50 kilometers to bring little bags of flowers or anthers. Of course, there is also then the physical protection. Of course, if you produce your seed in enclosed farms, barbed wire fences or whatever, I mean, you keep visitors and not so well wishers away. That also contributes to protect your germplasm. It goes without saying. Now, remove all ostentatious signs of belonging to a company. Don't go there with your east-west cap in the seed inspection fields. Remove any signs on cars, on whatever. Usually, seed production is a stealth activity, right? We should really be under the radar screen to really protect our germplasm. What we do also, and if you have the possibility, is that don't produce the seed where it is sold. So in East-West, we can do that. So we produce seed in one country and ship it over to another one, so that there is no temptation of stealing the material. Now, this is about the current document. We have been discussing of, what to do next with this document. It's nice, it's there on the site. What should we do with it? So, because this document is worked together with the ISF group, we agreed that we are going to amend this document together if ever we have to amend it. We also agreed, I think, that this document should remain very practical, down to earth, accessible to most, not very high scientific world, just give some very useful tips to all companies to do that. We hope to enrich this document gradually with a little bit more crop-specific information. This document, as you will see, is just a very general terms, but we hope to be able to come up with more crop-specific issues on crop-wise production protocol. Also talking a little bit about the system approach as an alternative of risk-based management. As you know that, I mean, you can mitigate your pests risk by following a very strict protocol on prophylactics in the field. So if you pay attention to many little detail, you can keep your field free from diseases and free from all this. So if we can enrich the document with that, that's an area where the document will go. So that's what I had for you. So thank you.
Thank you very much, Michel. I think we regard ourselves very privileged to have you here as one leader who has been leading this process. With a very enthusiastic group. I had also the opportunity once to be able to sit in one of your meetings. I think the important thing you emphasized is this is a living document. It's not static. No. Evolution goes on in the technology. Therefore, the thieves are also adapting their approaches. So we should be adapting ourselves when it need be. And I would again underline this came about to find a practical tool, because what is the situation, ladies and gentlemen? Too many times we are confronted with the fact that hybrids are illegally produced, reproduced, and found, sold all over the world. And when I ask them the question, the conclusion is the parental lines have been stolen and are being used by the thieves. And then you find yourself, unfortunately, faced that in legal terms, there's very little you can do. Sometimes you can do some, but in most cases, there's not much you can do. So therefore, that was the reasoning. We asked the question, what can we do ourselves to prevent this? So there's nothing better than to prevent theft. So in this respect, I think this practical tool gives you clear guidance how to, well, put extra locks on the door. And I realize that the seed production colleagues are probably not in this room, but those of you who have, say, general management positions or higher sales responsibilities, I would make an appeal to you. Make your seed production colleagues aware of this manual. It is online to be found. And also make your seed production colleagues risk management officers. So not only people who go around with the objective, produce seed at the lowest cost, but instead produce seeds at reasonable cost, but under the conditions which are safe. I think that is important. In view of time, I suggest, there's Francois, the one question, and I think then we have to.
Yes, I apologize, but some years ago, not so long, 3 years ago, the Office on Plant-Breeders' Rights in Vietnam complained about the fact that nobody was using plant-breeders' rights for vegetable varieties. So don't you think that the first advice you may give to vegetable companies is to use plant-breeders' rights when it exists in the country?
Yeah.
Because it's the first, you said, Casper, that it's illegal copy, but in many countries they are not protected in Brunei. So it's not illegal to copy something which is not protected.
Yes.
No. Yes, you're absolutely right, Francois. That's, I mean, that's the first recommendation, but this is again past that stage of registering the variety. Then what other things can be done to mitigate that risk? Because even though the variety has been registered, it's not free from being taken from you. So,
and Francois, right. If I may add, you're fully right. But a fact of life is that even in Europe, where I have most experience, it takes 4 or 5 years of legal procedures before you actually can stop the sales of illegally produced hybrids. So it's better, to stop to stop the thieves at the door. But you're quite right. PVP is essential. Thank you very much, Michel.
So now we have the discussions on our activities of the coming years. So we already have one agenda to understand the IP laws in APSA region countries through our survey. So we continuously to pursue you to complete the survey documents as early as possible. It will help you to understand and also help us to make some kind of papers which can support you if you want any kind of discussion in your own countries. Also, we have our position paper where we have many points to implement. We also have in that to share the DUS data. Also the reference variety information. So I think slowly we will move and the next year we want to look into these aspects of our position paper, that how we can implement within our Asian countries, APSA countries, that if we want to have the sharing of DUS informations, it is easier for the authorities to use their data and not to reinvent the wheel. So that is what our another agenda, to look into these areas where through our agencies we can put the DUS information on the net and where people can use or share the information through electronic mode. Any other issue which we take up, you have any suggestions? As the IP committee should take out for the discussion in coming year? If not, Casper, you have something to say and then we close it. Just 2 minutes, and, just 2 minutes to close it. Some kind of.
Well, I think I can be short and brief. Thank you. We come to the end of this session. And the only thing is that the APSA Secretariat and ourselves, Arvind and myself, would like to thank the speakers and also hand them a little gift from our side. So, Kuna, are you here?
No.
No? Sorry? There they are. And Dadiani?
Someone said yesterday that when we, at the end of the session, we thank everybody, it's just a formality. But then we at APSA do not take it as a formality. We feel that somebody has been able to give their time, and share their views and expertise with all other members. That goes to show a lot about their commitment towards APSA. And that needs to be recognized with a simple thanks. So at the end of this particular session, very lively discussions, and I have attended 4 of these sessions over the 4 years, and I find that the discussion level is evolving, particularly the participation from the people. And we like to thank the chair, Dr. Arvind Kapur, with a small memento. May I thank also Casper, our co-chair. Now I'd like to request the chair of the committee, Dr. Kapoor, to give away our mementos to the speakers. Anke, and Hurk. Mr. Motomura, or Tom. And Mr. Michel Devarrewaere. Can I request Michel, can you just stay back? Michel, can you stay back? Anke and Tom, can you please join us on the stage? Tom?
Yep, me too.
Yeah. Thank you so much. And now we close the session with this. And let me just remind you that after 15 minutes, we reassemble in this hall for the last technical session for the day, that is of the special interest groups on field crops. And I'd like to announce that those who have finished their questionnaire, which was circulated to all of you, if you have finished that, please return it at the counter at the entrance. Thank you so much.